Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I'm your host, Uncivil Law, a Texas and Virginia attorney who snarks at legal news on the YouTubes. If you're enjoying this content, please remember to hit that like button and subscribe for more legal fun. Today, we're going to talk about freedom of speech and diversity of thought in higher education. Why is this important? Because freedom of speech is essential for pursuit of truth, advancement of knowledge, and protection of individual rights. Diversity of thought is crucial for exposing us to different perspectives, challenging assumptions, and fostering intellectual growth. But unfortunately, freedom of speech and diversity of thought are under attack in many colleges and universities across the country. Some students and faculty members face censorship, intimidation, or even punishment for expressing views that are unpopular or controversial. Some administrations impose restrictive policies that limit where, when, and how students can speak on campus. And some activists try to silence or cancel anyone who disagrees with them. This is not only wrong, but illegal. The First Amendment protects freedom of speech for everyone in America, including students and faculty members at public education institutions and even private colleges and universities that promise academic freedom have a moral and potential even legal obligation to respect freedom of expression. In this video, we're going to look at some of the court cases that support freedom of education in higher education from conservative and originalist perspectives. We're going to see how the Supreme Court has ruled in favor of student rights against public universities that violates the First Amendment. We're also going to look at how some lower courts have ruled against private schools that have breached contractual promises of academic freedom. Let's get started with this. The first case we're going to talk about is an all-time classic, Tinker versus Des Moines. This is a landmark case that establishes student free speech rights in schools. In this case, public school students wore black armbands to protest the Vietnam War. School officials suspended them for violating a policy that banned wearing armbands as a form of symbolic speech. The students sued the school district for violating the First Amendment rights. The case went all the way up to the U.S. Supreme Court, which ruled in favor of the students. The court held that neither students nor teachers, quote, shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, unquote. The court said that students have a right to express their opinions on matter of public concern as long as it does not materially disrupt classwork or invade the rights of others. The court also said that students cannot be suppressed in their speech by their schools based on mere desire to avoid discomfort or unpleasantness. The court said that, quote, in our system, students may not be regarded as closed-circuit recipients of only that which authorities communicate, unquote. This case shows how freedom of speech protects students' ability to voice dissent on important issues without fear of retaliation from school officials merely because the speech is unpopular. The second case we're going to discuss is a follow-on case to Tinker, Mahoney Area School District versus BL, 2021. This relatively recent case extended Tinker's protection to off-campus students in the social media age. In this case, a high school cheerleader posted Snapchat messages expressing her frustration by not making the varsity team while using profanity and showing the middle finger. One message said, F school, F softball, F cheer, F everything. Another message said, love how me and another student get told we need another year of JV before we make varsity, but it doesn't matter to anyone else. The cheerleading coaches saw screenshots of the messages and suspended her from the junior varsity team for 1 year. The student sued the school district for violating her First Amendment rights. The case went up to the U.S. Supreme Court, which ruled in favor of the student. The court held that Tinker's standard does not apply to off-campus speech because it would give schools too much power over what students said outside of school hours and away from school supervision. The court said that off-campus speech has less potential to disrupt school activities than on-campus speech, and more potential to implicate students' privacy interests, autonomy, and parental authority. The court also said that off-campus speech has more alternative channels for communication than on-campus speech, such as social media platforms, blogs, podcasts, and other forms of communication that are not subject to school regulation. Court said there might be some circumstances where off campus speech could be subject to school discipline, such as where it involves severe bullying, harassment, threats, cheating, or breaches of school security. But the court said that none of these more limited circumstances applied to these particular Snapchat messages. The court also said that student speech did not cause any substantial disruption in the school or interfere with any school function. The court said that the school itself has an interest in protecting a student's unpopular expression, especially where expression takes place off campus, because American public schools are nurseries of democracy. This case shows how freedom of speech protections for students' ability to express their emotions and opinions on social media without fear of punishment from school authorities extends from Tinker's days of on campus speech to more modern days of social media and off campus speech. A third case we're going to discuss is Uzenkin Bonham versus Preswick, also 2021. This is another case that involves the challenges to a college's free speech area policies. In this case, two students at Georgia's Gwinnett College sued the college for violating First Amendment rights. The college had a policy that required students to obtain permission to speak in two designated so-called free speech areas, but these areas made up less than 0.0015% of the campus. The college also reserved the right to stop any speech that disturbs the speech and/or confronts a person. One of these students, Uzbek Zanam, tried to share his Christian faith with another student in one of the free speech areas after getting permission from the college, but he was nevertheless stopped by a campus police officer who told him some people had complained about his speech and he could face disciplinary action if he continued. Another student, Joseph Bradford, also wanted to share his Christian faith with students, but refrained from doing so because of the college's policy and Uzbek Zanam's experience. The students sued the college for violating the First Amendment. They sought an injunction to stop enforcement of policy and also nominal damages for injury. The college had tried arguing the case was moot because it had changed its policy and abolished the free speech areas. The district court had agreed and dismissed the case. The 11th Circuit even affirmed, holding that the nominal damages claim could not save the moot case. The case went up to the U.S. Supreme Court, which ruled against these decisions and also ruled in favor of the students. Court held that the nominal damages claim was a form of relief that can redress past injury caused by constitutional violation. The court said that nominal damages are not merely symbolic or technical, but rather represent a recognition of legal wrong and vindication of plaintiff rights. The court also said that nominal damages can prevent a defendant from escaping accountability by changing its conduct after being sued. This case shows how freedom of speech protects students' ability to challenge unconstitutional policies, restricting time, place, and manner restrictions at public colleges and universities. These are just a few examples of court cases that support freedom of speech in higher education protected by the Constitution. There are many more cases we could discuss, but those will have to remain for another video. But I hope you learned something new today about how important freedom of speech is and diversity of thought are for education and society. And I hope you'll join me in defending these values against those who wish to suppress freedom of speech and freedom of idea. Thanks for watching this video. If you like it, please hit that like button and share it with your friends. And if you want more legal analysis on current events, please subscribe to my channel and hit the bell icon for notifications. Until next time, remember, if you're going to be uncivil with style. Until next time, my friends, cheers and goodbye.